So the Honorable Chief Justice of Singapore, Mr. Sundaresh Menon, Mr. Neil Kaplan, who I know is joining us online, Mr. Christopher Toh, distinguished friends and colleagues. It gives me a great pleasure to welcome you to the 26th Goff Arbitration Lecture. This year's lecture is also being held as part of a year-long celebration leading up to CityU School of Law's 35th anniversary in September 2022. It is very fitting that our distinguished speaker's lecture will focus on the increasing complexification of disputes. Since the Chief Justice graduated in 1986 and I in 1987, we and many of you no doubt have found legal practice to have become greatly more complex. A reason for this is because the law has expanded significantly as societies have become more complex. This greater societal complexity has been brought about in part by advances in technology, which is also transforming the nature of legal practice. This evening's lecture addresses one aspect of this, namely the vast amount of data that can sometimes make the role of fact-finding, ironically, more difficult. This greater complexity in the legal landscape poses challenges for law schools. The challenge is made greater by the likely disruption that the legal profession faces. In such a complex, changing, and uncertain environment, what can and should law schools do? And this is an important question for us as we come to our 35th anniversary. The solution, in my view, is not to teach more law. It is, as ever, to make sure that through the medium of legal education, we stretch our students intellectually so that they develop the transferable intellectual skills to navigate change and complexity. These include the ability to be flexible, exercise good judgment, independent thinking, lifelong and collaborative learning, etc. But in today's world, more is called for. The broader knowledge base that lawyers need is a greater appreciation of other fields of knowledge that impact on the law so that students can better understand how the law intersects with other fields of knowledge, since law does not operate in a vacuum. I'm therefore pleased that when we begin our 35th year, we will also be starting 5 new interdisciplinary programs. 4 of them are double-degree undergraduate programs with accountancy, computing mathematics, criminology, and public policy. The 5th is a Juris Doctor MBA program. We will also be starting a joint degree program with Georgetown University, where our LLB and JD students can spend their final year in Georgetown reading the Georgetown LLM, with the credits earned being recognized by CityU. Broadening cultural and comparative context is another important aspect of our educational philosophy. In addition to these developments, we have since 2020 embedded accounting, business, economics, and technology into courses in our regular curriculum so that all students, right, I want to stress all students, will receive a broader interdisciplinary education fit for the future. Chief Justice Sundaresh Menon has in past speeches also spoken about what he believes the future of learning will resemble and the qualities that lawyers must possess in such a future. For example, in a speech on 27 August 2019 at the Mass Call 2019, he referred to 4 qualities that are required: agile learning, broadening learning, the willingness to learn together and from others, and the ability to acquire soft skills. He concludes that we can only remain a learned profession if we become a profession of learners. It is most reassuring that our distinguished speaker in this celebratory Goff lecture shares with us a similar vision of learning. This is something the Chief Justice can speak authoritatively on, given his wide and deep experience in the legal profession. This experience also makes him one of the most authoritative thinkers on the subject of arbitration. He practiced for many years with major Singapore and international law firms in the fields of commercial, litigation and arbitration, construction law, and insolvency law. Many, including myself, who have been on the opposite side in court or in an arbitration, will attest to his formidable, even fearsome, although always fair, reputation as an advocate. Within the judiciary, his rise has been meteoric. He first served as a Judicial Commissioner of the Supreme Court from 2006 to 2007. In 2010, he was appointed Attorney General and held such position till 2012, before his appointment as a Judge of Appeal. He was soon after appointed Chief Justice on 6 November 2012, the first Singapore-born Chief Justice. Chief Justice Menon is also the chairman of the Singapore Presidential Council for Minority Rights, president of the Singapore Academy of Law, and a member of the ICC governing body for dispute resolution services. It is now indeed my great pleasure to invite the Honorable Chief Justice to deliver the 26th Goff lecture. Chief Justice, please.
Thank you. Thank you very much. Good evening to all of you. And let me first thank my old friend, Cheng Han, for that very generous introduction. And let me also take this opportunity to thank Neil Kaplan, Christo, and the City University of Hong Kong for inviting me to deliver this year's Goff lecture. This really is a great honor. Few can claim to have made such significant contributions to the law in as many capacities as Lord Goff, first as a scholar, then as a practitioner, and last and perhaps most famously as a judge. Over the years, the Goff lecture has become a much anticipated fixture on the international arbitration calendar, and I am deeply grateful for the opportunity to make a modest contribution to this series. Today, as Cheng Han has said, I wish to speak to you about the complexification of disputes and to discuss the implications that this might have for our approach to dispute resolution. Those involved in the practice of arbitration will, of course, be familiar with the growing complexity of cases and the challenges that this poses to their efficient disposal. Much has already been said about the problems of undue delay and expense, and I do not propose to add to that already saturated discourse. Instead, I would like this evening to focus on what appears to be a growing class of disputes that are so factually rich and complex that they may be virtually impossible to adjudicate properly. This has been referred to as the complexity problem. The complexity of such disputes manifests in a number of ways, most commonly in the number of documents tendered, the number of witnesses and parties involved, and ultimately in the sheer length of the trial. Consider the Bell Group litigation in Western Australia, which was commenced in the wake of the collapse of a massive government-linked conglomerate. The proceedings culminated in a trial that lasted 404 days, in the course of which over 86,000 documents were tendered in evidence, and over 37,000 pages of written submissions were filed. The resulting judgment took 2 years to draft and consisted of almost 10,000 paragraphs. In another large contractual dispute litigated in New South Wales, 160 witnesses were called, who between them produced approximately 280 witness statements. And in a growing number of jurisdictions, most notably in the United States, class actions involving thousands and even hundreds of thousands of plaintiffs are not unheard of. To a point, complexity can be mitigated by keeping a firm and steady hand on the evidence or by placing limits on the length of written submissions. But cases like the ones just mentioned arguably go beyond the bounds of complexity that even robust case management can properly control. There are, after all, finite limits on an adjudicator's cognitive ability to process complex and voluminous information. And the concern is that some disputes are now so massive and complex that they have become extremely difficult for the adjudicator to fully and properly understand, much less decide. If this is the case with at least some disputes, we ought to consider just how serious the complexity problem is and what might perhaps be done to address it. This is the subject of my lecture today, and I propose to approach my discussion in three parts. First, I examine the origins of the complexity problem. For before we can assess the scope of the problem and its likely future trajectory, we must first understand what drives it. I suggest that the complexity of disputes is in part hitched to the inexorable advance of science and technology. And if this is right, we might expect that the complexification of disputes will only intensify with time. Second, I discuss the consequences that the complexity problem is likely to have for our ability to properly resolve such disputes, both in terms of its impact on the quality of judicial and arbitral decision-making, as well as the severe strain that it threatens to place, or perhaps already places on our justice systems. The point is that these problems arise because there are finite limits to the degree of complexity that we, as individual adjudicators and stewards of our justice systems, can realistically deal with. Solutions that enhance the efficiency of court and arbitration processes can help stretch those limits. But there will come a point when they cannot be stretched any further. And this will, I think, require that we turn to consider more radical responses, which entail reimagining the way we approach the resolution of complex disputes. And finally, I offer some suggestions for how we might light our way forward. Specifically, we might consider tackling the problem on three fronts. First, by re-examining our philosophical approach to the resolution of complex disputes. Second, by considering the use of novel procedures aimed at containing and downsizing large disputes. And third, by empowering and equipping people, stakeholders in the administration of justice, to address the challenges that complexity poses. Let me first examine the drivers of complexity in dispute resolution. There are, of course, more factors at play than I deal with, but in the interest of time, I focus on two related forces driving what I see as two distinct aspects of complexity. First, technical complexity, which is concerned with the increasing technical difficulty of the evidence that judges and arbitrators must today grapple with. And second, evidential complexity, which is concerned with the sheer volume of both documentary and oral evidence that adjudicators are regularly inundated with. I discuss each in turn. Let me begin with technical complexity. We now live in a golden age of scientific discovery. As our understanding of the world and how it works has become more nuanced and complex, so too have our disputes. Scientific advances have progressed our technical understanding of the physical world in a multitude of fields, and this has broadened the potential scope of the factual and legal inquiry that our adjudicators must undertake. Take, for an easy example, the impact that advances in the field of psychiatry have had on the complexity of criminal proceedings involving mentally disordered defendants. As early as the mid-13th century, English law already recognized a category of offenders who, by virtue of what was then referred to as insanity, had not the will to harm and ought therefore to be exempted from criminal punishment. One might draw parallels between the rather rudimentary understanding of mental disorders prevailing at the time and the simplicity of their legal description, which one leading authority described as manifesting in the, quote, furious man not much above the beasts which lack reason, close quote. Legal proceedings involving such defendants were fairly simple and straightforward. Declarations of insanity were made by a jury selected for their familiarity with the defendant and indeed with the fact that he was insane. And the legal result was almost invariably the receipt of a royal pardon and exemption from punishment. Today, nearly 8 centuries on, advances in psychiatry have equipped us with a far more nuanced and sophisticated, albeit persistently incomplete, understanding of how the human mind works. And with that, the ability to undertake more nuanced and sophisticated analyses of the fact that different mental disorders can have different consequences on moral and legal culpability. As a result, the factual inquiry in cases involving such defendants has become far more complex. Proof of the existence of a mental disorder, for instance, often involves adducing expert testimony from psychiatrists on, amongst other things, diagnosis of any mental disorders that the defendant suffers from, and how these might have impaired his judgment, with corresponding nuance in the legal consequences that might attach to that defendant. Putting advances in existing science aside, the advent of completely new technologies which concern novel science and create entirely new spheres of knowledge is another engine of technical complexity. Take, for example, the leaps that science has made in the fields of biogenetics. These have opened the doors to entire fields of new technological possibilities, such as genetic modification and cloning, and with them, minefields of thorny ethical and legal issues. Likewise, our increasing reliance on artificial intelligence and computer algorithms for decision-making seems yet another potential source of technically and legally complex questions. With computer algorithms, for instance, there are on the one hand deterministic algorithms which produce output according to a programmed, predetermined path, and for which legal responsibility may therefore be ascribed to a human programmer. And on the other hand, non-deterministic machine learning algorithms capable of autonomously developing their own decision-making processes, which present a litany of potential complications pertaining to causation, intentionality, and remoteness. Our increasing reliance on expert witnesses is a sure sign of the technical complexification of disputes. The technical depth of seemingly simple and everyday disciplines has significantly expanded the scope of matters which require specialized knowledge, lying beyond the professional experience of judges and arbitrators. Today, expert witnesses are increasingly called upon to give evidence on a whole range of disciplines, from accident reconstruction to statistics and even social media. Besides being called upon to give evidence in legal proceedings, experts are also regularly tapped to brief advocates and adjudicators on technically challenging subjects. In the United Kingdom, the Judiciary, in partnership with the Royal Society, publishes primers aimed at getting judges up to speed on the technical aspects of various relevant technology, including forensic DNA analysis. And in Singapore, in the Court of Appeal, we recently convened a technology tutorial in an appeal involving highly specialized and technical questions pertaining to a diamond manufacturing process. A written primer on the technical issues was prepared by the parties, after which the parties' experts, in the presence of counsel, orally address the court on the technical issues and their significance to the dispute. Some of this pertains to what Professor Mirjin Damaska refers to as the Scientization of Proof. This is the observation that testimony derived directly from sensory perception appears to have declined in importance in favor of expert testimony based on scientific methods and analysis. This is so not just because disputes increasingly concern technical issues outside the ordinary experience of judges and lawyers, but also because we now have access to tools capable of augmenting and even supplanting human sensory perception. We see this, for instance, in motor accident cases, where expert testimony on perception, reaction, timings, and frame-by-frame analyses of traffic camera footage are used to supplement or even to correct the motorist's account of what transpired. In these ways, the scientization of proof seems certain to further complexify the evidential process. And aside from the increasing complexity of proof, the complexification of legal regulations and rules as seen in the sheer number of laws and regulations that are promulgated is yet another engine of technical complexity. Professor Richard Susskind wrote nearly 25 years ago that the advent of technology may be driving regulatory complexity, a phenomenon he referred to as hyper-regulation. There seem at least two forces driving this. First, the need to regulate and address the legal and ethical concerns arising from these new and emerging spheres of activity enabled by technology. And second, the fact that the practical constraints that once existed on the quantity and the complexity of the law and the regularity with which it could be changed have gradually been eroded in this digital age. In other words, technology has enabled the easy creation, revision, and dissemination of rules and regulations. And there is a sense that this might, at least in part, be responsible for the proliferation of regulatory content. The second aspect of complexity I touch on is evidential complexity, which has exploded following the development of technology that make data cheaper and easier to generate and obtain. This has significantly expanded the universe of potential evidence that advocates and adjudicators alike must consider and review. Moore's law posits that computer processing capacity will double about every 2 years. Our appetite for information and data seems to have kept pace with, if not outstripped, that growth in capacity. In 1999, the world generated as much as 1.5 billion gigabytes of data in a year. Today, that same amount of data is produced about every 18 hours. And by 2025, it is estimated that that quantity of data will be created approximately every 5 minutes. The popularity of email and instant messaging have resulted in the creation and archival of an almost exhaustive documentary record of written communication. Even video and audio calls can be recorded and saved. Added to this is the data that is constantly generated by all manner of smart gadgets connected to the Internet of Things. There is also the data about the data, or metadata, such as information as to the size of an electronic file or when it was created. Today, nearly everything is recorded, almost nothing is deleted, and anything can be shared with anyone with a click or two. The ease with which data can be electronically generated, stored, and shared has meant that the volume of potential evidence available is now far beyond anything that existed in the 20th century, when records were predominantly created and stored on paper. This surge of cheaply available information and data has been dubbed the information explosion and has driven an increase in the evidential complexity of disputes in at least two ways. First, it has led to an unprecedented expansion in the scope of the available evidence that could be considered. Evidence may now be found everywhere, whether in the form of message logs, call logs, GPS location data, connections to wireless networks and the like, so long as one knows where to look and is inclined to look hard enough. Second, advances in technology have effectively removed the physical and logistical limits to the quantity of documents and other evidence that can be produced in court. And the increasing use of e-discovery that was intended to ameliorate the problem can instead exacerbate it. One 2011 decision of the US Federal District Court concerned the predicament of a party which had inadvertently taken on the obligation of reviewing and producing some 65 million documents dredged up by e-discovery search terms that it had agreed to. The court ultimately relieved the party of its ill-advised agreement, citing concerns over the cost of such an exercise, which would have run into the millions of dollars. But this illustrates the sheer volume of evidence that adjudicators, counsel, and the parties can potentially be called upon to consider. Clearly, technology plays a significant role in the complexification of our disputes. But I do not suggest at all that we should therefore reverse our course on the integration of technology within our legal and judicial processes. Technology, after all, holds tremendous potential in enhancing efficiency and access to justice. My narrower point is that rapid advances in information and communications technology appears to be driving, even supercharging, the complexity of our disputes. If this is right, and the pace of technology's advance is showing no signs of slowing down, then we must expect that our disputes will over time only get even more complex. And if we are therefore nowhere near the crest of the wave of complexity, then surely we should at least begin to consider the consequences that this emerging reality is likely to have on our justice systems and what we ought to do about it. I turn to consider these potential consequences on our ability to administer justice fairly and efficiently at two levels. First, at the level of the individual adjudicator, and second, at a broader systemic level. I begin with the impact that complexity has on the quality of individual decision-making, and therefore on our ability to do justice as between the parties. In a fascinating article, Professor Jörg Rieser describes the complexity problem in the following way. Consider an arbitration in which 10,000 pages of written submissions are filed. Assuming the arbitrator takes 6 minutes to read a page and therefore reads 10 pages an hour, it would take 1,000 working hours, or by Professor Rieser's reckoning, some 6 months of concentrated reading just to read through the submissions once through. And this does not account for the time she would need to refresh her memory of what had been read perhaps weeks or months earlier, to verify what had been said against the mountain of transcripts and documents, and to weigh it all against the equally hefty material on the other side before coming to a decision. Professor Rieser's point is that the demands that complex cases like these place on the adjudicator are next to impossible to meet. This is not for want of trying or lack of competence. The reality is that there are physical limits to our ability to process voluminous amounts of complex information. We can try to stretch those limits, but there will come a point where the quantity or difficulty of the material exceeds that which the human brain can properly process. What happens thereafter is what psychologists call information overload. And studies have found that this may have at least 3 consequences for decision making. The first is that the difficulty and quantity of the evidence in complex cases can render it extremely difficult to understand, as Professor Reese's examples show. There is some evidence that judges do in fact feel this way about complex litigation. Speaking extrajudicially, a former judge of the Federal Court of Australia observed that, and I quote, "One of the problems with complex cases is the feeling that it is big and that it can't be mastered." This is a very real problem. To decide a case, the adjudicator must be able to follow the evidence and understand it in order to be able to weigh it and forensically assess it. Extreme complexity threatens the adjudicator's ability to do each of these things properly, such that the biggest cases may become impossible to humanly comprehend, much less decide. The second consequence of information overload is that decision makers may become more prone to error. When useful and relevant information is buried in a mass of other information, that increases the chance that the relevant information is overlooked. Take, for instance, electronic health records or EHRs. These provide physicians with quick and easy access to a wealth of detailed information on the patient, ranging from past test results to detailed medical histories. In the belief that greater access to, in the belief that greater access to relevant information would increase the quality and efficiency of clinical decision-making, much was invested into developing EHR systems in hospitals and clinics in the United States. Yet, several studies have found that EHRs have failed to meet those objectives. And worse, they might even be contributing to errors in clinical decision-making. For instance, one 2013 study found that over a third of physicians reported that they had missed test results while looking at the EHR system because they were simply overwhelmed by the amount of information there. Other studies have found that information overload can decrease the accuracy of decision-making in many other contexts, from detecting dangerous items at a baggage check to making purchasing decisions in a supermarket aisle. What these studies demonstrate is that the most informed decision may not necessarily be the best informed decision. The availability of relevant information is a crucial ingredient in good decision-making, but an overload of information, even relevant information, can result in poor decision-making. Judicial decision-making is, of course, different in many important respects. Unlike physicians, for whom decisions might have to be made in the span of minutes or even seconds, judges and arbitrators will generally have more time to make a more considered decision. But judicial decision-making can also be more complex. And I do not think we have any basis for thinking that judges and arbitrators will somehow be immune to the effects of information overload. A third related consequence of information overload is that decision makers, especially when pressed for time and overwhelmed by data, may come to rely more heavily on heuristics and mental shortcuts. Human beings have an inherent need to simplify the complex world around them, and we do so every day through cognitive heuristics. These mental shortcuts help us filter out some things and focus on others. And they are essential to navigating the avalanche of information with which we are bombarded each day. But the problem with the mental frames we adopt is that they can also distort reality. One study found that jurors faced with complex cases tended to take mental shortcuts to reduce the cognitive load of the decision. For instance, by assessing the merits of a position based on the attractiveness of the communicator, or the communicator's credentials, or the number of arguments rather than their quality. Other studies, albeit not in the context of judicial decision-making, have found that decision makers tended to react to too much information by ignoring a lot of it. In short, when faced with more information than we can evaluate in an allotted time, human decision makers tend to try and find various ways to get by, thereby compromising the quality of the decision making involved. And this can be a dire concern in adjudication where accuracy is surely greatly valued. Judges and arbitrators are, of course, trained to resist such impulses. But these mental frames can operate subconsciously and may influence our decision-making without our even realizing it. This, I think, is the real danger we face in pushing ourselves beyond the limits of human cognitive capacity. For when confronted with an extremely difficult or even impossible case, the natural and seemingly noble thing to do is not to give up, but to do one's best and soldier on. But in doing so, and though we may not realize it, we run the risk that because of the complexity of the material, we cannot properly grasp it, that we miss important issues in the deluge of evidence and argumentation, that forensic analysis and logic give way to heuristic biases, and consequently, that decision-making devolves into what is, at best, informed guesswork. I suggest that those of us who hold a stake in our systems of justice must be alive to these possibilities. The old assumption that the most informed decision where is necessarily the best informed decision needs to be reconsidered. In a world where impossibly large quantities of evidence can be obtained and adduced cheaply, the most valuable commodity in a court or tribunal may no longer be information, but adjudicative time, focus, and attention. Inundating adjudicators with evidence, even conceivably relevant evidence, may serve to hinder rather than help them decide the case justly if they just cannot make sense of the flood of material. I turn to the second point on the consequences of complexity, which is its impact on our systems of justice. I have argued that extreme complexity can, in some cases, make it impossible or at least very difficult for the adjudicator to properly decide the dispute and therefore do justice between the parties. Yet, one might argue that impossibly complex cases are rare and that the vast majority of complex cases can be resolved if only the requisite time and effort were put into resolving them. Leaving aside the correctness of this premise, let me make 2 points. First, even those complex cases which are not impossible but merely very difficult to adjudicate will place an increasingly unsustainable strain on the system as a whole because adjudicative resources are limited. This may take various forms. First, there is the financial cost. In the Bell Group litigation, additional funding in excess of $4 million had to be provided solely to handle the appeals. And these expenses carry heavy opportunity costs. Discussing the Bell Group appeals, the then Chief Justice of the Supreme Court of Western Australia remarked in an interview some years later that electronic filing could have been introduced for a fraction of the amount spent dealing with those appeals. Then there is the systemic cost in terms of judicial time. During the life of a complex case, the judge in charge will usually have very little time for other matters, and this reduces the aggregate amount of judicial time available across the system for other cases and litigants. This is true not just for the duration of the trial, but also the usually lengthy pre-trial process and the considerable time that will be needed to write the judgment. In this way, a single complex case may displace many hundreds of other smaller matters, thus becoming an impediment to access to justice for the numerous others who must, as a result, wait in the queue. And there is also the personal toll that complex cases take on adjudicators. The prolonged stress, isolation, and the weight of responsibility that adjudicators shoulder when dealing with such cases should not be underestimated. This affects not just the individual adjudicator, but can also have system-wide effects if burnout leads to the early retirement of experienced adjudicators, thus further compounding existing shortages of this vital resource. In sum, complexity can result in real costs being imposed on our justice systems, even where that complexity does not cross the notional threshold of impossibility in the individual case. Beyond these costs to the system, there is a second, more fundamental reason why we must consider the consequences of complexity. Even if one takes the view that complexity is not yet of existential concern to our justice systems, that cannot mean that we should simply wait until it has become so. If, as I have argued, complexity is hitched to the inexorable advance of science and technology, then we must expect that the category of complex cases will continue to grow and that these cases will become ever more complex. There are already examples of such cases, and we should surely consider how we might best address them before they impose a debilitating burden on our justice systems. Let me pause to take stock of what we have covered. We began by discussing the sources of complexity in modern dispute resolution. I argued that technical and evidential complexity has largely been driven by advances in science and technology. Those driving forces are not slowing down, and this must mean that complexity is likely to increasingly feature in dispute resolution. In short, the complexity problem is set to get worse. We then examined the consequences of complexity. I argued that at a systemic level, complexity can place a heavy strain on adjudicative resources, while at the level of the individual adjudicator, the complexity problem in some cases is threatening our ability to properly and fairly decide such disputes. Together, these present what one might call a problem of finite limits. There are finite limits to the adjudicator's cognitive ability to understand and grasp complex issues and evidence, and there are finite limits to the resources that can be allocated to dispute resolution. We can try to stretch those limits, but taken together, it seems likely that it will only be a matter of time before the degree of complexity reaches the absolute limits of what our justice systems can accommodate. This has, I suggest, two implications at least for how we think or ought to think of the way forward. First, it means that responses which focus on stretching those limits cannot offer a lasting response to the complexity problem. Take, for example, tools and techniques which improve the efficiency of legal proceedings, such as encouraging the use of written statements, setting strict procedural timetables, and employing the use of video conferencing, or other remote methods of hearing, to name a few. These are undoubtedly helpful, but they can only take us so far. The use of Scott schedules, for instance, make the parties' cases easier to digest and may in this way stretch the limits of the quantities of evidence and arguments that an adjudicator may reasonably be expected to consider. But they cannot make an indigestible case digestible. A case so voluminous that it must be presented in thousands of rows in a Scott schedule is not ultimately more manageable than if it had been presented in thousands of paragraphs of prose. The point is that while such techniques can help expand our limits, these can at best offer only a part of the answer. My contention is that the problem is more fundamental and seems rooted in certain long-standing beliefs we have held about what justice entails and therefore what the role of the adjudicator ought to be. In particular, I argue that the problem stems from the assumption that justice requires, in every case, a full and exhaustive determination of the facts, and that the role of the adjudicator is therefore to determine the truth without compromise. Such a paradigm of justice may have served us well in an earlier, simpler time, but the complexification of disputes has raised serious questions as to whether it remains desirable or indeed feasible to insist that justice always invariably requires in each case an exhaustive search for the truth. This brings me to the final part of my lecture in which I offer some thoughts on a way forward. We might view this in terms of a need for change on three broad fronts. First, a large part of this will require change in philosophy. I suggest we need to shift our approach to the resolution of complex disputes by moving from a narrower view of justice as always requiring an exhaustive search for the truth to one which pursues the more realistic objective of facilitating the fair and orderly resolution of the dispute. The second is procedure. This will entail embracing processes and practices which can help contain the dispute where possible and to downsize it where necessary. And the third concerns people, and it involves equipping adjudicators with due awareness of the unique challenges that extreme complexity poses and arming them with the skills and knowledge that they will need if they are to address these challenges. Let me begin with philosophy, by which I mean our real quest in the resolution of complex disputes. Doing justice, it has been said, means applying the substantive law correctly to true findings of fact. This is the essence of our traditional adjudicative conception of justice, under which disputes are decided by an independent third party bound to apply the law to the facts. Because the facts are often disputed, the role of the adjudicator, as Lord Denning had put it, is to find out the truth and to do justice according to the law. Over time, this seems to have given rise to the notion that the principal aim of adjudication is a search for the truth. Justice Peter Corey of the Supreme Court of Canada put it in these terms. He said, the ultimate aim of any trial, criminal or civil, must be to seek and to ascertain the truth. Accuracy in judicial decision-making is undoubtedly important. After all, public confidence in any system of justice depends in part on its ability to produce accurate decisions that cohere with the law and the objective facts. But important as accuracy is, I'm not sure that this fully supports the claim that justice invariably and uncompromisingly requires a full and exhaustive determination of the facts. Let me illustrate this with 2 points. The first is a point of practicality. While a truth-seeking paradigm of justice may have worked well in earlier times, the complexity of modern disputes raises questions as to whether it remains feasible to insist on that defining objective. The claim of the complexity problem is that it will, in some cases, be either impossible or impracticable for us to fully and accurately achieve this end. Consider, for instance, a claim for damages in respect of thousands of defects in roadworks performed by a contractor. A truth-seeking paradigm of justice would require that each defect be individually verified and documented in evidence. Yet the cost of investigating, documenting, and eventually particularizing a claim in respect of each defect may end up exceeding the cost of rectifying them. That cannot, on any measure, be considered a just outcome. And the second is a point of principle. While the accuracy of judicial and arbitral decisions is a worthy and important goal, that seems on its own to be an incomplete conception of what justice is and requires. The search for truth must be and often is balanced against other values. We see this in action in various contexts. Take, for instance, the operation of the rules on legal professional privilege, which restrict the disclosure of potentially relevant and probative evidence in order to protect the sanctity of and candor within the solicitor-client relationship. The search for truth must also be balanced against considerations of efficiency. Most jurisdictions, including the United Kingdom and the United States, expressly recognize this in their civil procedure rules. The very first provision in the UK civil procedure rules, for example, states that the overriding objective of procedure is to enable the court to deal with cases justly and at proportionate cost. The same is true for arbitration. Article 22(1) of the 2021 ICC rules obliges both the tribunal and the parties to make every effort to conduct the arbitration in an expeditious and cost-effective manner, having regard to the complexity and value of the dispute. These provisions are clearly intended to be more than aspirational. Article 38(5) of the ICC rules permits the tribunal to take this efficiency obligation into account when making decisions on costs. And so an exhaustive search for the truth is by no means an overriding, uncompromising imperative of justice. In fact, an insistence on such proof might in certain contexts be inappropriate. For example, an exhaustive investigation into the truth might not be appropriate in the context of family justice if it succeeds only in increasing the acrimony between the divorcing spouses to the child's detriment. This realization has actually reshaped our philosophy and approach towards family justice from one geared to fact and fault finding to one that is directed towards healing and constructive collaboration. The broader point is that justice is not amenable to Procrustean definition. What it entails and therefore requires in each case depends on context. Accuracy is an important aspect of justice, and adjudication will, to a considerable extent, be concerned with ascertaining the truth. But an exhaustive search for truth is not always essential and may, in fact, sometimes be inappropriate. Yet, if adjudication is not a search for the truth, then what is it? I suggest that we are already seeing a shift towards a more holistic view of what it means to adjudicate disputes. One that welcomes the use of legal processes which have as their end not just the determination of the truth, but the resolution of the dispute in a manner that is fair and acceptable to the parties and that embraces procedures which whilst not as thorough, are nonetheless capable of producing reasonably accurate and broadly acceptable decisions more quickly and at far lower cost. This leads me to the second front of change, which pertains to the processes and procedures by which disputes are resolved. There are a number of legal processes and procedures which embody the new ethos of dispute resolution I've just outlined. On a previous occasion, I've suggested that these may be categorized in terms of two broad strategies we might take to deal with the challenges of complexity in dispute resolution. First, containing disputes, and second, downsizing them. The first strategy involves containing disputes before they become too large and complex to handle. This lends itself best to dealing with seemingly large disputes, which are in reality not much more than the sum of their smaller discrete parts. Such disputes are complex not because they involve any particularly technical subject matter or require the resolution of interlocking and interrelated issues. Disputes of this kind become large and complex, mainly because the resolution of their individual parts was not promptly pursued. Here, there may be considerable scope for the adoption of procedures which offer a truncated or much streamlined process capable of producing a good enough decision much more quickly and cheaply, so as to nip incipient disputes in the bud, instead of leaving them to fester and grow and assume unmanageable size. I can outline three such procedures. Dispute boards are the embodiment of this sort of process, and their use has been gaining traction in construction projects, particularly in North America. They involve the establishment of a standing panel of neutrals whose task it is to prevent disputes from arising and escalating by proactively identifying potential differences and disagreements with a view to resolving these quickly and informally, whether by mediating the dispute or by issuing a non-binding or temporarily binding decision. There is some statistical evidence to suggest that dispute boards are a cost-effective means of containing such disputes. Various surveys indicate that in 60% of the projects for which a disputes board was empaneled, no disputes crystallized, and where they did, more than 90% of matters referred to the board was settled without the need for further recourse to litigation or arbitration. And this is all accomplished at relatively low cost, on average for just a fraction of a percentage point of the overall project costs. Statutory adjudication has also seen considerable success in a number of jurisdictions, most notably in the United Kingdom, where it has become the most common dispute resolution method for construction disputes. Adjudication offers the parties a rough and ready means of obtaining a decision more quickly and cheaply with a considerably streamlined evidentiary process. While adjudication produces decisions that are only temporarily binding, the experience suggests that in most cases, the decision is treated as final and is not subsequently challenged by the losing party. And mediation too deserves mention. It has in recent years been increasingly used to complement adjudicative methods of dispute resolution. In the 2021 International Arbitration Survey, close to 60% of respondents expressed a preference for using arbitration in combination with other forms of ADR, such as mediation, to resolve cross-border commercial disputes. Significantly, this represented a significant increase over the 49% and the 34% who held that view in the 2018 and the 2015 surveys, respectively. As the cost of arbitrating complex disputes continues to rise, the popularity of international commercial arbitration will likely wane. And I believe that international commercial mediation might well in time take its mantle as the preferred means for resolving cross-border commercial disputes. And the Singapore Convention on Mediation, which provides for the international enforceability of mediated settlements, will undoubtedly boost mediation's prospects in the years to come. Procedures like these may not allow for as thorough a fact-finding process as a full-blown trial or arbitration, but their growing popularity even in the resolution of construction disputes, for which complexity is a common, if not definitional feature, seems a validation of the view that justice is sometimes better served by procedures which favor speed and economy over an exhaustive search for the truth. A strategy of containment works well when applied early in the life of a dispute, but where the dispute has already become so complex as to be practically unmanageable, a different, more drastic approach may be appropriate to aggressively downsize the dispute to a more manageable size. This might be done by placing firm limits on document disclosure, written submissions, time for oral submissions, and even on the time for cross-examining witnesses, or by encouraging the use of preliminary determinations which can help to significantly narrow the list of issues in dispute. Measures like these may initially draw cries of a breach of natural justice, but the question we should ask ourselves is whether justice really is better served by doing away with such limits and allowing the adjudicators to be inundated with evidence and submissions that we cannot reasonably expect will be exhaustively reviewed, understood, and evaluated. If some disputes are becoming so large and complex, it is perhaps better we acknowledge that reality and consider what can be done about it, instead of imagining that they are being dealt with exhaustively when they aren't. And if we accept this, we might consider other more radical means of downsizing these disputes. One such method entails the use of representative sampling. In a dispute involving thousands of defects, it may be practically impossible to insist on proof of each and every defect. In recognition of these difficulties, some have considered an approach where the result obtained in relation to a smaller representative sample may be extrapolated to the wider set. This was considered by the English High Court in Amy against the Cumbria County Council. There, the council claimed damages against a roadworks contractor for thousands of defects in patching and surfacing works. The council's claim was advanced on the basis of a sample set of the works, revealing a certain rate of defects, which it argued could be extrapolated to the whole of the works. While the damages in respect of the sample were worth some £22,000, that figure would rise to about £1.7 million if extrapolated to the entire works. The larger claim was ultimately dismissed on the basis that the sample evidence was found to be insufficiently representative. But the significance of the decision perhaps lies in the court's acceptance, at least I think in principle, of the council's argument that the substantial quantities of patching and surfacing works made it completely impractical for the employer to have inspected each and every item of work. Another way in which disputes may be downsized is by the adoption of voluntary protocols, under which the parties agree to carve out a set of excluded individual low-value claims, in respect of which recovery is pegged to the percentage eventually recovered in respect of the remaining non-excluded claims. Such a protocol is available for use in cases placed on the Singapore International Commercial Court's Technology, Infrastructure, and Construction list, and may help to further disaggregate an otherwise unmanageable dispute, such that it is only the crux of the issue that is dealt with in exhaustive detail. And a further and perhaps even more radical way in which disputes may come to be downsized is through the use of outcome prediction tools, which can support legal decision-making in various ways. Magistrates dealing with bail applications, for instance, often have to dispose of a high volume of matters within a short period of time. And some US courts have employed predictive tools which assist the human decision maker by providing an indicative assessment as to the likelihood that a bailee would abscond or reoffend based on algorithms developed from data sets comprising hundreds of thousands of cases. And similarly, e-commerce dispute resolution platforms, such as the eBay Resolution Center, which sees over 60 million disputes each year, face the challenge of having to deal with an extraordinary volume of cases quickly. The development of tools and algorithms able to predict the outcomes of such cases and so assist human agents in adjudicating such cases more quickly is already underway. There are, of course, technical and ethical limitations to the use of such programs for legal decision-making, and these limitations will have to be carefully debated and considered. But as the accuracy and accessibility of the technology improves and the discourse as to where and how such technologies may be meaningfully and appropriately employed matures, the use of predictive technology could in time prove to be a powerful assistive tool in the management of these complex disputes. Some of these protocols or proposals may be said to detract from the orthodox view that adjudication requires that the facts first be proved. But if we accept that adjudication is ultimately about resolving the dispute fairly, then we should be more open to procedures like this, which pave the way towards a fair and acceptable settlement of the parties' differences. And the last front of change concerns people. This speaks to the need to change mindsets and equip adjudicators with the tools needed to navigate a future in which complexity is a fixture. And I make just two brief points. First, more should be done to raise awareness of our limitations, what I have referred to as the limits of our cognitive ability. We would surely benefit from more empirical research on the effects of information overload, not just on adjudicators and decision-making, but also on counsel and the way cases are prepared. Change will only come if there is general acceptance of the serious consequences that complexity can have on our ability to do justice. Counsel and the litigants they represent must genuinely come to believe that their best interests are not served by flooding the adjudicator with information. And adjudicators too must accept that robust measures may have to be taken to contain the quantities of material placed before them. And in the case of arbitration, supervisory courts need to understand these constraints and make sensible decisions when deciding due process challenges against arbitral awards. Such acceptance of our limitations will more readily open us to solutions that bite the bullet and address these limitations, even if these might seem radical at first. And second, there is a need for more training and sharing of best practices amongst adjudicators. There is an enormous reservoir of judicial and arbitral experience in handling complex cases, and this needs to be consolidated, organized, and shared. Otherwise, it will be lost as members of the profession retire. Ladies and gentlemen, the complexity problem is still evolving. Its severity and extent remain to be seen. But the challenges it poses, I suggest, are best tackled prophylactically. As with many other ills, prevention will be better than cure. I hope that the suggestions I have put forward, while not pretending to be anything like a master plan for dealing with the issue, might offer us some basis upon which we might begin to seriously think about the complexity problem. The final point I want to leave with you is the idea of creeping normality, which describes the process by which even major changes come to be accepted as normal and acceptable so long as they happen slowly through small, often unnoticed increments of change. The problem of complexity seems to fit the bill. As the world becomes increasingly complex, things get just a little bit worse each year than the year before, but not bad enough for us to notice or protest. And this leads us to think that we are coping, and we continue to underscore our achievements in handling complex cases, managing gargantuan disclosure exercises, and writing judgments and awards that run into the thousands of paragraphs. The problem is that as we let the problem creep up on us without realizing the real danger, we might, like that proverbial frog, end up being boiled alive. The cauldron of evidential and scientific complexity is already beginning to heat up, and it has become uncomfortable. Countless experiments have shown that real frogs do in fact jump out of a hot pot. The question is, will we have the courage to do so? Thank you so very much for your attention.
Right, how do I? Can someone start my video? Can you hear me?
I can hear you, Neil.
Oh, good. You can't see me. That's probably an advantage. Let me just.
I would like to see you, Neil.
Let me pick up a few points and ask you a few questions, and then we can see if there are any questions from the floor. I mean, a lot of what you said, of course, is just what we want to hear as adjudicators. The real question is, how do we implement these ideas? Let's take one important point, and that's disclosure. I mean, I think what you're saying is, if you apply a cost-benefit analysis to the disclosure process, it wouldn't really stand any test. Far too much money is spent on it for far too little benefit. So the question is, how do you suggest we limit the disclosure side? And that really involves another question, which I think I know the answer to. Can it be said that those jurisdictions where there is no discovery or no discovery like we know it, can it be said that they have any less justice than we do? And so how are we going to go about limiting it? And is there a difference between arbitration and the courts, and what you're doing in the courts to limit disclosure?
Right. Let me take the point in three ways, Neil, and suggest three sorts of thoughts that come to mind about this. I really think that actually one of the most important things that we can do to start to meaningfully address the issue is to create the awareness that this is a reality. I first touched on this issue at a speech that I made earlier, much shorter speech, and didn't explore all of the points, but I touched on it at a speech that I delivered to the Academy of Construction Lawyers. And when I put this forward, there was actually a sign of, how should I put it? There was a sign of almost of relief that somebody had said or spoken the unspeakable, that somebody had actually articulated it and said that this was what was going on, and nobody dared to say it. And that made me feel that actually the point really was worth highlighting and really was worth getting a lot of attention to, because unless we talk about it, unless we come to recognize and accept it as a reality, nothing is going to change. So part of the solution, I think, begins with making it clearly a proposition that people talk about and recognize and come to accept that the cognitive limits are real. And because the cognitive limits are real, there are real consequences to what we as adjudicators are supposed to be doing. And the people who are at the front end of this process, the advocates, the clients, the general counsel, if they come to see it, perhaps that will shape the way they think about it. So that's the first point I would make. which I think is a very important point. The second point I would make is picking up now, going in specifically to a point about discovery. I completely agree with you. You said that you sort of knew what my answer was going to be. I think that the old Peruvian guano approach to discovery made sense when it was the difference between 100 documents and 200 documents. It doesn't make sense when it's the difference between 2 or 3 arch lever files of documents and 200 or 300 arch lever files of documents. And that's the reality. And that's the reality because the scale of material, of information, of disputes has just exploded. My experience, I'm almost certain that's your experience as well, is you sit in a hearing room with hundreds of lever arch files of documents, thousands of documents, but you end up looking at relatively few, but they're all footnoted and they're all there in the submissions, and you're supposed to work your way through a lot of them, even when they're not ultimately going to be material or decisive. And one really has to ask oneself the question of whether we have lost sight of the incremental benefits and the point you made, the cost-benefit analysis of where this goes. And the validation of that is in the second point you made, which is this is not the universal system. Neil, I recall 20 years ago arbitrating a case for an Italian contractor, and it was a very big dispute, a hydroelectric project, and you know how those are. And in the course of preparing for the documents, I found a document which I genuinely thought ought to be disclosed, and it was harmful to our case. And the Italian client looked at me shocked. He said, you know, if this was in Italy, you'd be arrested for breaching your duties to the client, right? So my point is, I mean, we've grown up in a certain system. I'm not saying that that's a bad system, but my point is that there are many systems where, forget Peruvian guano, I mean, even documents that are harmful are not expected to be disclosed. And it's not the case that you don't have justice in those systems. It would be wrong for us to say that. So we do need to re-examine the way we think about these issues. And I can relate to you one point that we are taking in Singapore on the 1st of, well, very, very soon. The process actually started a few years ago when I established a Civil Justice Commission to look again at modernizing the rules of civil procedure in our courts. And one of the things they're looking at is exactly this point. And the draft rules will be published very, very soon. But those rules will have quite a different approach towards the question of discovery. So I do think that there are ways in which we can deal with it. There are ways we should deal with it. And arbitrators in particular have far more scope to deal with it because of the procedural autonomy they enjoy, and because of the respect that courts do accord arbitrators in matters of procedural autonomy in particular, as long as the basic rules of natural justice are observed.
Well, let me just jump in there a minute. You're sitting as an arbitrator, and you say you should only produce the documents you seek to rely upon, and that's it. And they both say, no, we want full discovery. We want the old-fashioned thing. What do? Do you say, no, you can't have it? Or do you say, well, you agreed to have it, you're stuck with it and stuck with the cost, even though it might make my life a misery in a few weeks' time?
It's not, my point, Neil, is it's not just your life that's going to be made miserable. We are talking, this is not about the inconvenience for adjudicators. My quarrel with this, my issue with this is not driven by the problem of inconvenience for adjudicators. It's really driven by a genuine concern that I don't think the material is being dealt with. It's not just a cost concern. I mean, cost is the visible, direct, obvious manifestation of the problem, and the fact that it hits the pocket of the client hopefully incentivizes people to take a sensible view at it. My real point is that it's just not being addressed. It's just not being addressed. And if you go past discovery, you look at the length of the submissions. I mean, the examples given of submissions going into the thousands of pages. Neil, when I took office as Chief Justice, one of the things I did was to put an absolute limit on the length of the case in the Court of Appeal. And there were howls of protest from the bar. And I said to them, listen, we've got 10 appeals a week. It's far more likely that we're going to read a 50-page case than if each of the cases were 200 or 300 or 400 pages long. It's not going to happen. And that was what was happening. So
just take yourself back to the days when you were the advocate and I'm the arbitrator. And I say, at the very beginning, you can only have a 50-page submission. I think you might get a bit excited if you had a very complex case and you couldn't get it into 50 pages. How would you cope with that?
I had to cope with it. And I had a real case where this happened with one of our friends, Bernard Anatio. And I was appearing before him in a complex case. I obviously can't talk about the details of the case, but it was a complex case. And there were common law counsel on both sides and Bernard in the middle. And we both, in our discussions before the case, thought that this was going to take 3 or 4 months of hearing because it's a complex technical case, a lot of documents. And Bernard basically looked at us at the first hearing and he said, I'm going to give you 10 days of hearing time, and you're going to finish this in 10 days. And that means we're going to have limits on submissions, limits on discovery, limits on cross-examination. And look, Neil, we were both quite upset, but we had to do it. And the case settled eventually, not just because of the pain of having to make our case within those limits, but we did it because we had to.
Yes.
So I don't think that, yes, it's difficult. It does require a change of mindset. I completely accept that.
So I think you'd agree with me too, that the awards are too long.
I agree.
And they're probably too long because of the things that you've been outlining.
Exactly.
What goes in has to come out somehow. You have to deal with it.
Exactly. Right. And Neil, if I can just butt in, the additional problem is many arbitrators feel the need to do this because otherwise you get a silly argument that, I put this point in footnote 3 or 376 at page 74 and the arbitrator hasn't dealt with it. Yes. Therefore there's a breach of natural justice. I mean, that's wrong. But so the arbitrators feel obliged to deal with every last point, which adds to the whole problem.
I mean, that's caused in some respects by the desires of the institutions to make sure that everything's in.
Yeah.
That can be a bit of a difficulty. So do you think judgments are too long as well?
I hope that we are generally shorter than you are. And I try to be shorter as far as I can. Yes, I mean, I think it is. We can all do more. We can all do better.
Yes. Let me just. You touched on mediation, and of course, I think we all agree that you must never underestimate the abilities of a trained mediator to crack the impossible case. I've always wondered why it isn't the rule in court that you can't get a case set down until you've been through a mediated procedure, unless the judge says it's not an appropriate case for such a procedure.
I think we will, speaking for myself, I think we will end up with that position in reverse. In other words, there will be some cases where we can mandate, as it is, it's almost mandatory in family cases that you have to mediate. But apart from that, I think in Singapore, we will end up with a situation where judges are empowered to order any case to be mediated or to attempt mediation. And I think that our experience has been extremely positive. And I think we both know that. I think that, part of the problem is many advocates feel that going down the line of mediation might have tactical or strategic giveaways. But actually, the experience has been that the vast majority of cases where you do have a mediation, I mean, the success rates are so encouraging that it should be the default in most cases.
Yes. I mean, you mentioned that the combination of mediation and arbitration, and that's a big topic, and I don't think we've got time to go into that. But one of the things we're doing now is to create a pause in the timetable at appropriate times to say that nothing's going to happen during this period. If you want to mediate, this is the time you might want to do it.
Yeah.
We don't want to know about it. But it's a bit of a problem for the arbitral tribunal to get involved in suggesting mediation.
Yeah.
I know that it's encouraged in some places, but it's a problem.
Yeah.
And one of the problems is, you know, the odds are they've already tried it or they've already discussed it.
Yeah. I have a couple of views on how I see mediation growing. I think the complexity problem will ultimately hit the pocket, what you started off talking about. And because it hits the pocket, I think we will see people needing to find more sensible ways to resolve this. Now, until now, the big problem with mediation that many people would counsel their clients not to get into was the fact that you're going to give away all this information, take positions, and you can't even enforce it because you're just substituting one agreement with another. And if the person's a scoundrel who doesn't perform the agreement, they're going to breach the next agreement. And at a certain level, even though I don't think that was borne out by the real experience of commercial parties, at a certain level that had some appeal. That's gone now. It will be gone. And I think that the fact that people's pockets are being hit by the cost of litigation, in large part because of complexity, and the fact that you can effectively enforce a mediated settlement, those two things, I think, will come together to change the game. And I see this as being where the scope will come for development. And people will start thinking more and more about developing integrated solutions that take this into account.
I mean, I was very fascinated with your discussion about the cognitive side. And I remember Lucy Reed saying in a lecture many years ago, it's not a question of how much you can get into an arbitrator or judge's head, it's how much you can keep in there. And there is a limit.
Absolutely. Absolutely.
Yes. I mean, in your practice did you ever come across a smoking gun that justified, you know, the great search for that one document that changed the case?
I struggled to think of a smoking gun. There were a couple of smoking guns which were given away in the evidence, for example, but rarely in chain of inquiry type of discovery chases. And I mean, if I were to be really honest, Neil, I would have to say that most of the time when I did engage in chain of discovery types of battles, they were procedural guerrilla tactics, if you know what I mean. And I think if advocates were really being honest about it, a lot of the time these are wars of attrition that they're fighting. And fair enough. I mean, if the rules allow you to do it, you do it. You know, I mean, they're not unethical, they're not wrong, but you're not doing it because you seriously expect that you're going to find that smoking gun. You're doing it because of a whole lot of tactical benefits that you think you will get, and more often than not, you do get those tactical benefits. I think if my memory is not wrong, the one case where there was some smoking gun type things was in a banking dispute where chasing the internal credit memoranda gave me some very useful materials for cross-examination, and that brought about a settlement in the end. But you know, that was over 20 years of litigating. That was one out of many.
Yes, I was interested in your reference to dispute review boards because, I mean, they are absolutely wonderful for the large dispute, the large claim, the large projects. But they're not much use really for the smaller case.
I agree.
On the other hand, the dispute resolution advisor idea is quite a good idea for the smaller cases.
Yeah.
If you can appoint a dispute resolution advisor to supervise your dispute and to sort out how to best handle it, and even to help you get the right tribunal if you have to go to an arbitration. We haven't seen a great deal of use of that, though. Do you think there's a likelihood of that getting more traction?
That I do, for a different reason. And I think that the reason I do see it coming on board, mainly because I think that the next frontier that all of us in dispute resolution will have to think about, I see two big frontiers: the complexity issue, which is what I've talked about today, but the other thing is the question of access to justice. And there is a real problem with access to justice, which is not where the complexity problem is, but even without the complexity problem, it's just the disproportionate cost of pursuing your remedies with the existing architecture for procedures that exist both in court and in arbitration. And I think that that is going to be a real issue because internationally, inequality, the pushback from globalization that we're seeing, all of those are manifesting an underlying real concern with access to justice. And I see that as driving innovative solutions like the Disputes Resolution Advisor, who's there to actually steer the parties towards a sensible outcome. Yeah.
Do you see any advantage in changing the attitude towards costs? I mean, do you think that costs follow the event is really causing cases not to settle or make them less likely to settle? Do you think that if people knew they'd have to pay for their own costs, they wouldn't throw the kitchen sink? They wouldn't spend so much if they didn't think there was a chance of getting it back from the other side?
It's a very, very interesting point. And I think it can go both ways. To be honest with you, I think there are arguments that go strongly both ways. For those of us in the common law tradition, we've always thought in terms of cost follow the event, but in court anyway, and in my court, I suspect in some courts anyway, the cost follow the system, cost follow the event system is not actually coming close to covering the real outlay of the winning party. So it is there, it helps, but it doesn't actually hold harmless. So that raises a further question as to whether it's really ultimately beneficial or not. But one can also understand the injustice of a party who has had to litigate wrongly, who has been wrongly forced to litigate. One can understand the dissatisfaction of having to incur enormous amounts of costs. And if you look at the best example for this, it's America, where they don't have that system and it has done nothing to rein in costs. I'm not sure it's done anything much to rein in costs. Instead, you've had, in some ways, new ways of dealing with it, such as through contingency fees and that sort of thing, which have created a whole lot of other problems. So it's a really difficult issue, which I think, but Neil, I would respond to this ultimately by saying these are the issues we really need to be thinking about because this problem is here to stay.
Yeah. Now, I'm very, except that I'll be taking up all your time, there must be some questions from the audience. Shall we see if there are any in Hong Kong? Anyone got any questions you'd like to ask the Chief Justice? Yes. Is there a microphone?
Chief Justice, can you hear me okay?
I can, thank you.
Okay, great. Thank you so much. Just have a question. Thank you so much for spending your time with us at the City University of Hong Kong. It's great to have you here. Just a quick question that's a little bit off topic, but I think related to what your thesis is in terms of your lecture here. I guess first, what is your view on the future of arbitration and mediation in Hong Kong? As you know, there's been some strategic challenges for the last few years in Hong Kong, and I'm curious to see if you have a view from your perch in Singapore as to what the future and what some of the positive, I think, aspects of Hong Kong's competitive position for arbitration and mediation is in the future. And second, what's your recommendation to arbitration and mediation students in terms of their study of this topic, and what do you think are some of the things they should be paying attention to moving forward? Thank you.
Thanks very much. How do I address you? I'm sorry.
Can you give your name, please?
Jonathan.
Jonathan. Thank you. Thank you very much, Jonathan. In my time as an advocate, which is going back some time, I had the great privilege of doing quite a lot of disputes work in Hong Kong, both arbitration and mediation, as counsel. And I have to say, I think Hong Kong is blessed with an incredible pool of talent in both these fields. I came across some of the most impressive mediators in Hong Kong in my time as an advocate. And certainly in the field of complex arbitration, I think some of the cases that have been dealt with in Hong Kong are probably amongst the largest that were dealt with in my time as an advocate. Now I'm 10 years at least out of date, but that informs my perspective on Hong Kong's standing as a center, which is that I think it will remain a critically important center. And it will remain an especially important center because of its geographical proximity to probably the most important economy in the world, which is China. And people who have investments or projects or commercial activities in China will naturally, I think, tend to a greater extent than anywhere else, think of Hong Kong as the place they go to raise their money, to get their legal services, to resolve their disputes. And the Hong Kong Judiciary and the Arbitration Center have been doing a number of very, very good steps in securing that in terms of arrangements with the PRC. So I continue to think that Hong Kong will be a critically important center in the world of dispute resolution, not just in Asia and the world. And I would venture to say that if anything has happened over the course of the last 2 decades, it is the fact that, in my view, we today have 2 centers in Asia that can take their standing as reputable international centers for legal services. And Singapore, I think, has joined Hong Kong in that bracket. That's my perspective. And I actually think that's a tremendously positive development, and something that I think that we collectively should take tremendous pride in, that Asia will, in my view, I've said this for a number of years, I think Asia will be the center of economic activity in the world, looking for the next 20, 30 years at least. I think it'll be a critically important center for economic activity in Asia. And if you think about it, the fact that we have 2 leading centers with strong courts, strong pools of lawyers and arbitrators and dispute resolution professionals is something we should be incredibly proud of and incredibly optimistic about. Because the rule of law is what is going to secure the growth of investment looking into the next few decades. So I would be really quite optimistic and bullish about this on the first point. The second point that you talk about is something that's, Jonathan, extremely close to my heart. Cheng Han knows this because I've done quite a lot of speaking and talking and thinking about the future of legal education. And I think that we are due for a major reset. I heard Cheng Han's opening remarks, and I wanted to congratulate Cheng Han because I think that the City University is doing absolutely the right thing in developing 4 or 5 joint programs, because I think that the way we think about the law, those people in Neil's and my generation, we sort of thought about the law as a discrete field of study. We sort of thought about the law as something that only lawyers knew, and that's all lawyers needed to know, because that equipped them with the special knowledge from which they could solve problems in a legal way. And I think that assumption has got to be thrown out the window because, in part, coming back to the subject of my remarks this evening, in part because of the growing complexity that science has forced upon us. Just to give you one example, and I talk about it just because it was the most one of the more recent things that we had to deal with. But a year or two ago, we dealt with a case involving algorithmic trading and contracts that were formed by algorithmic trading. And in the Court of Appeal, we had to deal with the consequences of this in the context of unilateral mistake. And how do you transport the principles of unilateral mistake that were made in the context of two people sitting down and meeting and talking to one another and forming a contract? How do you transpose those principles to a field where the contract was concluded by two computers that somehow communicated with each other and concluded a contract? Now, the point I'm making is a large part of that was trying to understand the technology behind what was going on. And you needed to understand that in order to figure out how far you could transport those principles that were developed in a physical context into that virtual space. And that's, I regard as one of the simplest manifestations of the types of issues we're going to have to deal with. So my view is we really need to rethink the way we approach law school. And one of the first things that I would be thinking about from the perspective of trying to sit down with a blank piece of paper and design a law school curriculum would be things like having multidisciplinary education, things like infusing areas of study so that people grow up not just to know the law, but to understand how the law is going to operate in today's context. And more importantly, perhaps equip them with the skills to think in terms of how the law is going to operate in tomorrow's context, because it's all going to change, and it's all going to change very dramatically and rapidly. And unless you're ready for that, you're going to be extinct and outdated and obsolete very fast. And we can't afford that. And the danger is that we in most common law countries, we're still teaching law. And I limit myself to common law countries only because I don't know enough about civil law countries. But in most common law countries, we're still teaching law essentially the way it's been taught for a couple of 100 years, maybe more. And I don't think that's appropriate anymore because the world has changed so much in the last decade, and it's going to change so much more in the next few decades that now is the time for us to rethink how we think about the law. I also think that with greater complexity, with the types of issues we're going to face, our legal firms and our legal professionals are not going to be limited to LLBs. You're going to have computer scientists who do coding for lawyers. You're going to have people who understand computers and codes to do discovery and to manage documents and to convert all of this stuff into a way in which you can use the technology to make sense of it. So you're going to need people like logistics people, you're going to need to deliver a project, you're going to need computer scientists, coders. So the way a law firm is going to look in 10 years' time, my guess, is going to be quite different from what we have been accustomed to. And we should be training our law students with that picture in mind. So I think this is an incredibly exciting time to be a law school educator. But the problem is I'm not sure that many of our stakeholders are enthusiastically on the same page yet. And it's going to be, the struggle is going to be getting the key stakeholders onto that page. But I think it's going to happen very fast.
Right. Well, I think I just realized it's quite late in Hong Kong. So unless there's any other burning question.
Neil, there's one question which I'm very happy to take. It's on the chat.
Right.
And it says, have we applied blockchain technology in the Singapore judiciary? And the answer I can give you very, very quickly is not yet, but we looked at whether to apply blockchain technology for the authentication of judgments. And we came up with an even simpler solution to authenticate judgments using QR codes. And we've done that. So we can authenticate judgments by simply using a QR code. And that can work anywhere in the world. But we will be, I'm sure, turning to blockchain technology before long.
Mm. Well, I just wanted to end by thanking you very much for the time and effort you put into this very thoughtful lecture. And I'm very pleased, and I'm sure everyone else will be pleased, that you'll be returning to this topic, in a sense, in a few weeks' time in the Freshfields lecture, when you're looking at the importance of procedure in the pursuit of justice, which I'm looking forward to very much. It's always great to have you come and talk. You have wonderful ideas, and you've been an inspiration to so many people. So thank you so much for your time, and thank you so much for adding to this great collection of Goff lectures that we've been able to put together over so many years. Thank you again.
Thank you, Neil. I want to thank you. I mean, you and I know each other well, and it was very kind of you to invite me, and I was greatly honored, and I thoroughly enjoyed working on the lecture. I thoroughly enjoyed presenting it, and I thoroughly enjoyed our conversation. So thank you so much, and thank you to all of you for having me.
Thank you very much, Chief Justice, for your vision and foresight, and we hopefully will look forward to seeing you in Hong Kong.
I look forward to that, Chris. Thank you.
And on this note, on behalf of the university, City University of Hong Kong, the School of Law, the Dean, Professor Tang, and everyone here, all the students, the graduates and so forth, it was a real pleasure having you, and we look forward to having more cooperation with you in the future. So on this note, may we wish you all the best, good health, and hopefully see you soon.
Thank you so much, and thank you all, and good health to all of you. Good day.
Bye.
Bye-bye.